Okay, and who's going to be the next witness?
The next witness will be Dr. James Ipser.
Okay.
Shall I call him?
Yes.
Please swear or affirm that testimony about to give be the truth, the whole truth, nothing but the truth.
I do.
All of the
Morning, Doctor.
Morning, sir.
State your name, please.
Dr. James Reed Ipser, that's I. He is in Paul, SDR.
And what is your professional address?
Department of Physics, University of Florida in Gainesville.
And are you a professor?
I'm now a professor emeritus. It means I'm no longer actively teaching. I'm retired from active teaching.
Describe your educational background for the jury, please.
Yes, sir. Okay, so I grew up in New Orleans, and I received an undergraduate degree in physics there, for Loyola University in New Orleans. And then I was accepted as a graduate student at the California Institute of Technology, or Caltech, as it's commonly called, in Pasadena, California. And there I received a master's degree in physics. Then in 1969, I got my doctorate, or PhD, as it's called, in theoretical physics at Caltech. And then spent 2 years as what's called a fellow doing research in physics. I did that for 1 year at Caltech and then for 1 year at the University of Washington in Seattle. Then I got my first faculty job. I was an assistant professor, then an associate professor with tenure at the University of Chicago, where I taught for 10 years from 1971 to 1981. And in 1981, I moved my family back south and took a position as a professor of physics at the University of Florida. I've been to that institution since then, although in the interim, there are a couple of other things that are involved. In the late 80s and early 90s, I was employed part-time during the summers and sometimes during the academic year as a scientific consultant at Livermore National Weapons Laboratory in California, where I was part of a scientific team doing what we call secret or classified work that actually involved collisions of what are known as ballistic missiles, which can bring in weapons. We try to develop methods to stop that from happening. And since the early 90s, I've been using physics to analyze accidents of various kinds.
And what is your professional background besides being a professor at the University of Florida?
Well, all my degrees are in physics, and I have extensive training in various aspects of physics. And as I said, professionally, as far as professional work goes, the two things that I mentioned were this consulting work with the weapons lab, and then accident reconstruction, what we call biomechanical physics, stuff that I've been doing since the early 90s.
Do you have any certifications?
Yes, I have a certification from the international organization known as the Society of Accident Reconstructionists, which recognizes me as someone who's professional enough to come into an environment like this and offer opinions. Also, I developed a graduate course at the University of Florida, which has a certification. I should mention that too. I created a course called the Physics of Accident Reconstruction and Biomechanics, and I taught that to graduate students at the University of Florida for many years, and that course was certified by the state university system as part of its graduate curriculum.
All right. Prior to today, have you ever testified before a court as an expert witness?
Yes, so I've testified more than 250 times in court now, both federal and criminal and state court, circuit court, mostly in the state of Florida, but in some other states too.
And you're retained as an expert for litigation, correct?
Yes, right.
And have you represented both plaintiffs and defendants?
Yeah, I have. I'll take a case from wherever it comes and see what I can do.
And have you ever told a client that you can't help them because your opinions weren't favorable?
That's happened, yes.
At some point in time, you were retained by my law firm, correct?
Yes, sir.
All right. And when was that?
Well, I have a cover letter dated October 9, 2013, so that would have been the first hard copy communication. I'm sure there was a call before that, but wouldn't have kept any record.
Okay. Now, you charge for your time, correct?
I do, yes, sir.
All right. And how much do you charge per hour?
Okay, so for my work up on a case, reading documents, doing calculations, $275 an hour. The only different component is like sitting here in the box testifying. So while I'm actively testifying, sitting here in a deposition, as it's called testifying, I charge a little bit more for that, $425 an hour for that component.
Okay. Do you know how much time you put in yet? Today?
Goodness, let's see. Yes, so I have an invoice for $2,885, but that doesn't include my preparation for the trial coming here.
Okay. Now, in this case, we retained you to perform an accident reconstruction, correct?
Yes, sir.
All right. And describe to the jury what you do as an accident reconstructionist, starting with explaining what physics is.
Okay. Physics is the basic science of nature, which tries to understand the way that the world works at its most fundamental level. So it governs all aspects of what's going on around us at the most fundamental level. And in particular, the most basic area of physics is something which is called mechanics. And mechanics deals with the motion of objects and how that motion is affected or influenced by what we call forces that act on objects. So an object will change the way in which it's moving, or maybe even change its structure or shape because of what we call a force, a push or a pull that acts on it. This fundamental area of physics called mechanics tries to understand all of that. That's the basic tool that one would use, for example, today. For what I'm here today for.
All right. And what is accident reconstruction?
Accident reconstruction involves taking this fundamental tool of physics called mechanics and applying it to what we call an accident. An accident consists of a sequence of events, one coming after the other, and they all have a relationship. One causes the next one that comes along. And what the accident reconstructionist tries to do is to put together all of those events and see how they all affect each other and cause each other to come in time, how they all fit together in a coherent way.
Okay. Now, you looked at the photographs of the vehicles involved in the accident, correct?
I have.
And are those important in your analysis of accident reconstruction?
Yes, sir. So one of the key elements in doing this type of activity is understanding the forces that are involved, forces between the vehicles, for example. Well, the evidence of the forces between the vehicles is contained, at least partially, in the crush that the vehicles exhibit. That is, when the vehicles push on each other, they can cause damage on the surfaces that are coming into contact. And so the question in any case is how much damage is on those surfaces of contact, because that gives one information about the forces that are involved. That is, how hard the vehicles are pushing on each other, and in turn, how fast are they going.
And did you determine that there was any crush damage to either vehicle?
Not that I could see, no. Not on the surfaces of contact, no. There could always be what we call collateral damage hidden underneath, but there's a partial movement of the bumper systems. But for example, the surfaces that came into contact with the bumper systems, they all came back. They're all in their original positions. They haven't been preserved in those positions.
Run the analysis through with the jury on how you conducted your analysis, applying what you utilize, the photographs, anything else, and how you came to your conclusions? What was your methodology?
Yes, sir. So the way that one proceeds in this particular case, at least the way that I proceed it, I first look at all the information that's provided. So that would include photographs of the vehicles, accident report, which enabled me to identify the vehicles. Once I have that, then I can go out and collect information or data on the physical characteristics of the vehicles. So I identify the vehicles, then I go to the various databases that are available that enable me to collect the information that I need about the physical properties, weights, dimensions, and also how strong the bumper systems are, for example, the surfaces that came into contact with each other. So once I have that information, and once I have the information or evidence about the crush damage sustained by the vehicle, or lack thereof, I can then put that all together in a physics calculation, again using this fundamental area of physics called mechanics that I alluded to earlier, to calculate quantities associated with the accident. The first thing that one is interested in calculating is what we call the approach speed or the closing speed. That is the difference between the speeds of the vehicles at the moment of contact. Now, in this case, we have testimony that the Cadillac is sitting at rest. So the closing speed, excuse me, in this case, would be the speed at which the defendant's vehicle is moving, backing up in this case, when it made contact in front of the Cadillac. That's the first thing one wants to calculate. As I said, I use the properties of the vehicles and the crush damage evidence or the lack thereof in the photographs. Now, when you do that calculation, you have to put in something about the crush damage on the surfaces of contact. Well, we don't see any here. So in that case, one does what's called a worst case scenario calculation, where he or she allows for the bumper systems to have been pushed in as far as they can be temporarily without showing permanent crush damage. So if you have a contact between two vehicles and the bumper is coming to contact, the bumper of the vehicle can be temporarily pushed in a little bit because of the force that's acting on it. If that force isn't too great, then the bumper system will come back to its original position. So in a case like this, where we see no crush damage of any significance, what we have to do is to allow, in the worst case scenario, for the possibility that the bumper system, say the Cadillac, was temporarily pushed in as far as it could be without subsequently showing any permanent crush damage. It could have been pushed in a lot less than that. But in the worst case scenario, one would allow for it to be pushed in all the way up to the point where if it were pushed in any farther, it wouldn't come back to its original position and would show permanent crush damage. So that's the worst case scenario calculation that one does in this particular case.
All right. And as a result of your analysis of the accident, were you able to reach some conclusions as to the speed of Dr. Baptiste's vehicle
Yes.
at the time of the accident?
I was. Okay.
And what was that?
Okay, so putting all that information in, and I'm repeating myself, but I'm allowing now the bumper system of the Cadillac had been pushed it all the way up to the point of permanent crush temporarily. That places an upper limit on the speed for the Baptiste vehicle. The speed at which it's going when it comes to contact with the Cadillac. 8.5 miles an hour. It can't be any greater than that. All right, so that's the maximum speed at which the Baptiste vehicle could be backing up when it made contact with the Cadillac. Now, it could be a lot less than that, as I said, for the reasons I'm giving. But that would be the maximum.
All right. Thank you, Doctor.
Just like maybe two questions real quick, Doctor.
Yes, sir.
You said you had $2,800. I think you paid $2,800 before preparation for trial here today.
Yes, sir, that's true.
And when you got paid $275, I don't even mention this. Did you get $275 an hour for driving or two?
I will be. Haven't been paid yet.
Okay.
I haven't billed for it yet.
Okay, you drove down from Gainesville?
Yes, sir.
Okay, and that's all I have.
Okay.
Okay, any other questions?
No, Your Honor.
All right, thank you, Doctor. You may step down.
Your Honor,
question.
Oh, I'm sorry. Yeah, go ahead and write your question down.
Okay.
And then I'll ask the attorneys to, as soon as that question is completed, to come to the bench.
Won't be able to read it.
Try to make it legible. Okay, I think we have a second question, but we'll take a look at the first question. Okay, Doctor, I'm sure you're aware Florida has a unique system that allows jurors to ask questions. So we have 2 questions from the jury. I'll ask the first question first, and it's a multiple question. Does the doctor's car have a bumper system? Would his plastic bumper show damages if it pushed her car's bumper all the way in?
The vehicle can be pushed in temporarily, the bumper, without showing any crush damage. The amount by which it can be pushed in without showing any crush damage temporarily is 3 inches. If the Cadillac bumper is pushed in 3 inches, up to 3 inches temporarily, it'll come back to its original position without showing any permanent crush damage because of the absorbing properties of the bumper system.
Okay, you have to write it down again. And a little more legible next time.
I have a try.
I know, that's okay, that's okay. Now, the attorneys will have an opportunity to follow up with all of these questions once we're able to let you. Okay, I'll ask the attorneys again and then we will follow up his question before we go to the other juror's question. All right, and the question from the juror is, do both cars have that system?
They do.
Okay. All right, we have another question from another juror, and I'll read the question, Doctor. Question, how much force is applied at the 8.5 mile per hour speed from the Chrysler on the Cadillac based on its weight?
Okay, so the 8.5 mile an hour speed exerts a force on the Cadillac, which is 1.5 times its weight in this worst case scenario. And the weight of the Cadillac is about 4,000 pounds. So in the worst case scenario, in which case the bumper is pushed in temporarily 3 inches and comes back to its original position, the Chrysler exerts a force of 6,000 pounds for about a tenth of a second on the Cadillac.
Okay, and do we have any follow-up questions by the attorneys? I guess the plaintiff can go first.
For the question, John.
All right.
For the question.
Okay, any additional questions from any jurors? All right. Thank you, Doctor. You may set it.
Thank you, Your Honor.